it's Candice Quinn from Contract Hack, and I'm here to talk to you today about commercial loans. I have a feeling a lot of you probably slept through this class in law school. It is a bit of a snooze fest if you aren't interested in finances, and so I thought that we all could use a really good refresher on commercial loans and what a lawyer's role is in a commercial loan transaction. Here's the thing, whether you're in-house, at a firm, or even in a government position, commercial loans are everywhere, and it's going to be nearly impossible to get away from understanding the moving parts of a commercial loan transaction. So first, what is a commercial loan? It's any loan made to a business rather than to a person. Think business acquisition, real estate, equipment purchases, working capital, anything that a business may need money for, a commercial loan is available to finance it. Of course, the lender gets to specify all of the terms and conditions of the loan based on the business's history, what the loan is for, etc. And unlike consumer loans like your residential mortgage or your credit cards, business loans are completely unregulated by the government. Everything is negotiable, from the term to the amount to the interest. All of it can be negotiated. Everything ends up getting documented, and if you're not careful, it can all just blow up. So what is a typical deal structure? Well, you've got your borrower, the business that needs money, and you've got your lender, the bank or private equity, etc., that is willing to give money to the business for this specific purpose. And sometimes, depending on the size of the deal, there may even be a syndicate of lenders rather than just one lender. The borrower is going to use the loan for a specific purpose, whether that's to buy real estate or do construction, acquire a competitor, whatever. You name it, if it is legal, a lender will probably loan money to a borrower for that purpose. In exchange, the borrower is going to give the lender collateral. So that may be a mortgage against the real estate. It may be a general security interest in all of the borrower's assets, no matter what those might be. So that would include accounts receivables, inventory, all assets like equipment, intellectual property, and real estate. And if the borrower defaults on the loan, well, the lender can seize all of their property. So what are the key agreements that are part of a commercial loan transaction? Well, there is some variation. There is a set of core documents that you're going to see every single time. First, you are going to see the loan agreement itself. It lays out how much money, the interest, the repayment terms, etc. But most importantly, it also contains the covenants, which we will get into in a little bit. Another document that you will always see is the security agreement. This is going to be the document where the lender officially gets a security interest in all of the borrower's assets. Now, if there's also real property, there may be a mortgage or deed of trust included as well. You are also going to find a guarantee agreement in every commercial loan transaction. The borrower is an entity in a commercial loan, so the lender needs some backup in case the borrower goes belly up. So the lender is going to ask the owner of the entity to come in and make a guarantee if the borrower fails to pay, which means the owners are personally putting their personal assets on the line if the borrower fails to pay. There's also typically going to be UCC financing statements to back up the security agreement. These would be filed for anything that's not real property that the lender is taking a security interest in. And this puts everyone else on notice that these assets are already securing a loan. Now, if there are multiple lenders, then you also may see an intercreditor agreement, which is basically an agreement between lenders as to who has priority in which situations if the borrower defaults. Okay, so let's talk about covenants, because this is where the real meat and potatoes of the commercial loan are going to live. Covenants are all of the restrictions and obligations that the borrower agrees to meet in order to get the loan. Some of these need to be met before the loan is funded, and some of them need to continue to be met post-funding, or it would cause a default of the loan. There are two flavors of covenants. There are both affirmative covenants, things that the borrower must do, and then there are restrictive covenants, which are things that the borrower cannot do. So affirmative covenants would be things like file taxes and provide financial statements. Examples of restrictive covenants might be that the borrower cannot take on more debt without the lender's approval, that the borrower cannot sell major assets without approval, or that the borrower cannot merge with another company, also again without the lender's approval. A third category is financial covenants. So this is things like meeting certain financial statement requirements, not just providing them, but actually meeting certain numbers, meeting EBITDA requirements, minimum liquidity requirements, and minimum debt to equity ratios. If the borrower fails to meet a financial covenant, this is going to give the lender the immediate right to call a default on the loan and start collection action against the borrower. Now, it should go without saying, but if you represent the borrower, you are going to want the loosest covenants possible. Whereas if you represent the lender, you are going to want the tightest covenants possible to make sure that the bank is repaid its money. So what roles do lawyers actually play in a commercial loan transaction? Well, if you represent the borrower, you're going to be reviewing the term sheet and the commitment letter. You are going to be making sure that all of these terms and conditions of the loan reflect things that you believe your borrower can actually do. And you are probably going to be advising and guiding them on some of these terms and conditions based on what you know about their business and their finances. You're also going to be negotiating the loan agreement and seeking flexibility in the covenants. You want to make sure that your client can actually run its business under the covenants. It is possible that they could be too tight for your client to continue business in normal course. So you definitely want to make sure your client has the flexibility to run its business so that it can repay this loan. You're also going to be handling corporate governance, things like resolutions, unanimous consents. All of those things are going to be really integral if you are representing the borrower. Now, if you are the lender's counsel, then you are going to be drafting all of the agreements, so the loan agreement, security interest, the guarantee, etc. You're also going to conduct a lot of due diligence on the borrower, so you're going to be reviewing title reports and financial statements, existing contracts, payoffs on other loans, etc. You'll also perfect the security interest by filing the UCC statements after the closing, and if there's a mortgage involved, you'll also be taking care of that as well. If you're a newer attorney, well, you're going to be deep in the due diligence and reviewing of documents, and you might also be preparing a closing document list to make sure that the lender has everything that is needed from a due diligence standpoint as well as from a document standpoint so that everything can be filed and perfected appropriately. Now, if you're in-house on either side, you're going to be managing outside counsel as they go through this process for you. Your job is going to be facilitating the conversations between the lender and outside counsel or the borrower and outside counsel. You're going to need to understand the business deal so that you can explain it to the lawyers, and then the lawyers can go ahead and document it or negotiate it as appropriately. You're actually going to be the one triaging issues, figuring out what comes to light first, what priority each issue takes, rather than the one actually deciding them or negotiating them. Now, what does the closing of a commercial loan look like? Well, first and foremost, it is or can be complete chaos. Nowadays, people are all sitting on a Zoom, they are signing electronically, emails are flying around, DocuSign messages are flying around. Everyone is trying to make sure that everything got signed as it needed to be, everything is notarized per requirements by the state, etc. Until everything is perfect, nothing is going to fund. So if you're the attorney representing the lender, you need to make sure that everything was done correctly, because the worst thing you can do is tell the bank to fund the loan and you don't have a document signed. When that funding finally happens, the wire hits, that's when it's time to celebrate. Everyone is going to take a big sigh of relief, maybe clock out for the day depending on the time of the day or the size of the deal, because it would have been a long marathon up until that closing time. If you represent the borrower, you're immediately going to shift into compliance mode, making sure your client understands what they need to do next in order to stay in compliance with the loan. So what are some common pitfalls? Well, one is not understanding the business. Whether you represent the lender or the borrower, having an understanding of the borrower's business is really important to make sure that the negotiation runs smoothly and accurately represents the risk to both sides. 2, Loan agreements are really intense, like they're really dense and thick. And if you don't understand all of the definitions and all of the terms being thrown around in there, it is easy to miss something that could put your borrower in default right away. 3, never ignore the inter-creditor dynamics, whether there's more than one lender in your transaction or there was an existing lender and you're adding mezzanine financing over top. You need to understand the dynamics and make sure they are specifically and clearly laid out so that neither lender is left out in the cold should the borrower default. 4, failing to calendar covenant deadlines is also a pretty big deal. If you represent the borrower, it's very important. They will not remember. You need to be the one to help them remember. So this is going to be something to flag. Have your assistant or paralegal task this to send a reminder. Now, if you represent the lender will typically handle this and you don't need to worry about the covenants. Once it's closed, you are pretty much off the hook, except for one thing. Lenders Counsel will typically provide an opinion letter that basically speaks to the enforceability of the loan and the loan documents. This is a pretty big liability that the Lenders Counsel takes on, and the lender is definitely relying on that letter in order to have a backup should the borrower default and they lose in court in a collection suit. So the bottom line is, while you may be dealing with millions and millions of dollars in a commercial loan transaction, these are not glamorous. It is a lot of paperwork, and typically, no matter the size of the loan, there is still a lot of paperwork and it is all very similar. The things that you are negotiating won't substantially change based on the amount of the loan. It's just that people are a little bit more emotionally invested in the higher amount loans. Understanding commercial loans not only makes you a better lawyer, but it makes you a better business person. You will understand how businesses functionally take care of their finances, what they need to do in order to meet certain covenants, etc. It is really an eye-opening experience the first time you get to go through one. I like to call it a masterclass in all things legal and business because there are so many legal issues that can come up, from real estate to past mortgages, uncleared UCCs, etc. It is very helpful to learn a lot of different areas of the law at one time. So if you're thinking that you'd like to dive deeper into a transactional practice, go ahead and set up a free call with me. The link is in the pinned comment and the description below. I would love to chat with you and help you figure out how to reach that career goal. Bye for now, hackers.